For the bill, for the resolution, we have Nelson Roach with Texas Trial Lawyers Association.
My name is Nelson Roach. I represent myself and the Texas Trial Lawyers Association, and I am speaking on behalf of or for the resolution. The Texas Court of Criminal Appeals is an anachronism. It was created by the Constitution of 1891. At the time that the 1891 Constitution was enacted, there was a three-member Supreme Court. It was the sole method or sole avenue of appeal in the state of Texas. Every case in the state of Texas that was appealed, there was an appeal by right to the Supreme Court of Texas. The court became overburdened, and as a process to unburden the court from its overburdened workload, the Court of Criminal Appeals was created. At the time the Court of Criminal Appeals was created, there was only one level of appeal in the state of Texas, and there were two courts. There was one court that handled the criminal side. There was one court that handled the civil side. This process continued, and as it continued, the Texas judicial system has evolved. It evolved in such a way that when the civil docket became overburdened, there was courts of civil appeals that were created, and that ultimately became the courts of appeals that we have now. In 1981, there was a major court reorganization bill that became law that was passed by the legislature. At that time, the issues that were brought up were the problems with the Court of Criminal Appeals, the overburdened Court of Criminal Appeals at that time, because at that time you had an intermediate appellate court in the civil system, you had no intermediate appellate court in the criminal system. At that time, it was proposed that the court be eliminated. The reasons why are the reasons that remain today why the court should be eliminated. One is the concept of interest group capture. In 1981, when the issue was raised, instead of seeing the prosecutors' organizations step up and say that we think the Court of Criminal Appeals is a good thing, what you had at that time is you had the criminal defense lawyers that were defending the Court of Criminal Appeals, and you had the prosecutors saying this is a terrible court, we need to get rid of it, which underscores that first issue of interest group capture. People think they have an advantage with a specialized court. Specialized courts, especially at the appellate level, are special interest courts. In addition to the problem of interest group capture, a specialized appellate court has the problem of a lack of cross-pollination of ideas. In other words, what you expect in an appellate court situation is you expect your judges to come from different disciplines and to exchange ideas in order to come up with the state's policy. When you have specialized courts, you don't have that. What you currently have here is that all of the Supreme Court judges have a civil background, all of the Court of Criminal Appeals judges have a criminal background. You don't have that cross-pollination of ideas, which leads to the third problem with a specialized court, and that is conflict in decision. There were two excellent articles that were, oddly enough, that appeared in the Texas Monthly that were written by a gentleman, I believe his name is Michael Hall, and it outlined problems with the Texas Court of Criminal Appeals in terms of conflicts in rules of evidence decisions compared to decisions that are made by the Supreme Court. And the point of the article is that when you have these two courts that are basically ignoring each other in their decisions on the rules of evidence, that breeds a lack of respect for the court. The third problem is that the Court of Criminal Appeals, by having a specialized court, it's become an anonymous court. And what I mean by anonymous court is I would venture a bet that even though we have a majority of lawyers on this committee, that the members of this committee would be hard-pressed to name two judges on the Court of Criminal Appeals. And I would suggest to you that having a specialized court of criminal appeals diminishes the prestige of both courts. And the reason why I say that is because when it is time, for example, for federal nominations to occur in the Texas system, if you'll notice, unlike a lot of other states, there are very few Texas Supreme Court judges over the last 40 years who have been nominated to federal benches. And I think, as far as I know, at least for the latter half of the 20th century and into this century, there has never been a Court of Criminal Appeals judge that has been nominated to go to a federal bench. And the reason is that when the selections are being made, when the nominations are being made, one of the questions is, do you have a general background, a generalized background serving as a judge? And those judges lack that background. So the point, though, is that having a specialized Court of Criminal Appeals and a specialized Texas Supreme Court diminishes both courts. It diminishes the prestige of both courts. It diminishes the reputation of both courts. And unlike other branches of government, our court system doesn't have an army. It doesn't have police. Our court system depends upon respect and prestige in order to operate. And so anything that can be done to increase that prestige is a good thing. There's a lot of other reasons that I could go into as to why, in my opinion, having two different appellate courts is not a good idea. It's not a good idea from an efficiency standpoint. It's not a good idea from an administration standpoint. As far as the changes that would be made with incorporating Mr. Schofield's bill into Mr. Raymond's resolution, we would generally support that idea with the understanding that this is a evolution towards the process of eliminating this court. Going back to what I talked about earlier about what happened in 1981 when the courts of appeals were created, the reason at that time that the Court of Criminal Appeals was not eliminated is the argument was that the courts of civil appeals needed time to adjudicate criminal cases that could be reviewed by the Court of Criminal Appeals in order to gain the expertise and knowledge in criminal cases so that the Court of Criminal Appeals could be eliminated. The 1981 legislation was enacted with the understanding that it was an evolutionary interim process to the eventual demise of the court. And we think that that's what should happen. I think it would make our entire court system better.
Mr. Chairman,
Mr. Raymond?
are you familiar with whether or not at the federal level we've ever contemplated having two Supreme Courts, federal and criminal?
No. In fact, the only other state in the country that has a separate Supreme Court to handle criminal matters is Oklahoma. And unlike Texas, the caseload in Oklahoma is still so low that there is no intermediate appellate court jurisdiction in criminal cases. So in other words, in Oklahoma, all criminal cases go to the Oklahoma Court of Criminal Appeals. In other words, Oklahoma is like Texas was 100 years ago.
Right.
And in that regard, with regard to specialized appellate courts, the federal system has a couple of specialized federal appellate courts, one of which is the Court of Appeals for the Federal Circuit, and it has, since its creation, come under pretty intense criticism and scrutiny for the idea that it is subject to interest group capture. It is hyper-partisan. There are camps on either side because every judge is a specialist in the area that comes from that discipline. And the same problems that we're talking about here are the problems that there are at the federal system with those specialized courts. I think that if Mr. Schofield's bill is rolled into your resolution, that it is a step in the process of transitioning away from this court, even though it's been now, 34 years since this process was supposed to have started. We do have expressed, with respect to Mr. Schofield's bill, some concerns we had, one of which is the idea that we think that if the issue of an appeal is the constitutionality, that there should be a two-way right of appeal. That, in other words, the criminal defendant, if the criminal defendant's appeal is on the grounds of either unconstitutionality or the prosecutor's ground that a bill is constitutional, that was declared unconstitutional, in any event, the final arbiter of the Constitution should be the Supreme Court. And we think that would be a good first step in the process of transitioning away from this court, from the Court of Criminal Appeals, to a judicial system that is more like every other jurisdiction in the country but Oklahoma. Thank you.
Mr. Schofield?
I think I heard you to say that, one, as usual, Oklahoma's 100 years behind us, and that the court should have their own army and police force. I think those are the two things that I took away from that.
No, not that they should get their own army and police force. No.
Mr. Clardy?
Thank you, Chairman. Mr. Roach, let me ask you this. This is a concern I have. You and I both practice civil law. I don't do any criminal law. Do you have any concerns that because of that, I think appropriately so, we put issues of liberty and life ahead of property issues? So criminal appeals take priority over civil appeals. Do you have any concerns if the courts were hypothetically merged, that it would in any way hamper the ability of civil appeals, or be there's always some time period built into the briefing process. So it should not be a quick resolution. It should take months or longer for a resolution. But in laying those two things on top and always having these issues of life and liberty, criminal appeals, would we see the civil docket being pushed back?
No, I don't think so, and here's why. Due process requires one level of appeal. And so the courts of appeals are competent to handle that one level of appeal that due process requires as a matter of right. The second level of appeal is not a matter of right, it's a matter of discretion. And so just as the U.S. Supreme Court has a writ of certiorari, so can that be and is with the Supreme Court today. And that's another aspect of how our system is evolving. When we had one layer of appeal, when we had a Supreme Court and then we had a Court of Criminal Appeals, there was not a discretionary right of appeal. It was an absolute right. And we had the common law system of writ of error. When I first became a lawyer, we didn't have, questions presented and things like that. We had points of error and writs of error. And it was a writ system. And it was an absolute right of appeal, and the appellate courts had to hear every case that was presented.
That was back when we still used law books.
Back when we used law books, right. Which I still do. And so we've transitioned away from that towards the discretionary model, which makes sense if you have an intermediate court, because your intermediate courts are your due process right of the first layer of review.
Okay. And I will say, with all due respect to Chairman Raymond and Mr. Schofield, the point you made tonight, I've heard for the first time in this entire argument. These are very bright individuals who've argued this point with me. I will confess, I'm a bit of a dinosaur. I think if things aren't broke, let's don't fix them. I like things traditionally. But the point you made about Texas' inability to put up for serious consideration to a seat on the United States Supreme Court because we've not trained our jurists in both disciplines is compelling to me, because Texas needs representation on the Supreme Court.
If you remember when Harriet Miers was nominated,
right.
One of the big arguments against it was she was a civil lawyer, she had no criminal experience,
right.
And any judge from the Texas Supreme Court, if they were to be nominated to an appellate bench, if they were being nominated to the U.S. Supreme Court, the same issue would be brought up to say, this judge has no experience, not only in the criminal sector, but they also have very limited experience in the constitutional sector. And I think it does hold us back in terms of the judges that come out of the state court system. I think you have a better chance of being nominated to a federal bench if you're a trial judge in Texas or if you're a court of appeals judge than you do if you're either a court of criminal appeals judge or a Supreme Court judge.
That makes sense. Well, Mr. Roach, thank you for your testimony. I know the next bill up is a really important bill. We need to get laid out promptly. So, but thank you for your testimony.
Thank you.
Thank you very much.